Welcome everybody who's logged in to our 5th countdown to the UPC webinar. Now, if you've joined us for previous webinars, you'll know that we've dealt with more structural issues around the court, such as its competence, decision-making, and its role in the wider patent litigation context. And we've also looked at the unitary patent itself. Now, this week in this presentation, we're going to focus on the very important question of what the court can do for its users, in particular in the form of preliminary injunctions. And I am joined by my colleague in Düsseldorf, Christoph Turner. For the first half of the talk, I'm going to talk about the broader aspects of what and where with preliminary relief, and then Christoph is going to get stuck into the detail of how you get it. Before I go on to talk about preliminary injunctions themselves, it's probably worth doing an update on the latest developments, because it was before the summer that we had our last webinar. Quite a lot's happened in that time. In particular, the 18th draft rules are now circulating, dated at the 1st of July. So that's the 18th iteration of the detailed rules of procedure of the court. This latest iteration adds clarification in particular of the meaning of proprietor of a patent for the purposes of largely of opt-out. It also adds clarifications on the written procedure, in particular the timing of pleadings. What it doesn't contain at the moment is the agreed court fees, and this will be one large addition still to be made in the next iteration, which could be the last or the penultimate issue of the rules. So we'll find out more about that hopefully later in the year. 8 countries have now ratified, with 5 still needed, and remember that out of the 13 needed for the court to come into force, the UK and Germany are obligatory. And whilst we understand that the UK and Germany intend to ratify, it's still yet to happen. Another large development is the agreement by the preparatory committee on a protocol for a provisional period. And the purpose of that is that the court will start on a provisional period, possibly as early as the beginning of next year, in which the court can appoint a registrar and other key roles, and it will also be able to record opt-outs. But the court itself will not become fully functional. In other words, it won't accept cases until a later date still to be set, possibly early 2017. The other development is that unitary patent renewal fees have been published by the UPO, but as I said, draft court fees, although a proposal was circulating and there was a consultation on it, have yet to be finalised. So we look forward to hearing more about that, possibly in October. So on to preliminary relief, and what can you obtain in the UPC? Well, this is all governed by Article 62, that's the headline provision in the UPC agreement. That says you can have a preliminary injunction against an alleged infringer to prevent an imminent infringement or the continuation of an alleged infringement. So the infringement may have started already, in which case you want to stop it, or you can have it on what's known as the quia timet basis, which is where you've got evidence that the infringement is about to happen, you can stop it before it happens. A curiosity about the rules is that as well as preliminary injunctions being available against alleged infringers, the rules also say, and it's the second little bullet down the screen, that they're available against an intermediary whose services are used by the alleged infringer. Not entirely clear what that means. It could be read, on looking at it at first blush, to be quite broad. What's an intermediary after all? It could be a supplier of a common reagent, perhaps in pharmaceuticals side of things, or it could be a supplier of electronic parts. What the more likely meaning of that seems to be is that it's intended to cover indirect infringers. that is, suppliers of means relating to an essential element of the invention, or suppliers of staple commercial products who are supplying them inducing an infringement. It seems clear that intermediary doesn't go beyond those articles on indirect infringement. So turning on to the next slide, there is some associated relief also available with preliminary injunctions under Article 62, where the court thinks it's appropriate to support the injunction. It can order the seizure or delivery up of the allegedly infringing products, either to prevent their entry into the supply chain in the first place, or to prevent further movement of them in the channels of commerce if they've already gone onto the market. Furthermore, but far more rarely, certainly in national experience, is the use of freezing orders where there's an endangerment to the recovery of damages because the defendant has sequestered their assets or moved assets offshore in some way that they're outside the jurisdiction of the UPC. In those circumstances, unusual as they may be, precautionary seizure of the defendant's property, certain property, or the blocking of bank accounts is available. So, what exactly is the scope of an injunction? This is quite an important thing to remember, given what I was saying about ratifications. The court can start with just 13 ratifications, but the Unitary Patent, in principle, covers 25, and it will be 26 when Italy has declared it will do joins. So the scope of injunction for a unitary patent in the first place is those countries that are participating in the unitary patent, currently 25, they're again limited by those who've ratified. So beginning of the court's life, it may only be 13, so that's something to bear in mind. Also, as far as European patents are concerned, it's European patents that haven't opted out of the system, injunction can only be used for those patents, it's fairly obvious, for those patents that are actually registered. So it may not be in all the European countries, it may just be a handful. Again, they have got to be, the country concerned has got to be contracted to the UPCA, the UPC agreement, and the country concerned has also got to have ratified. So that may not cover the full 25 to begin with. So, with that in mind, let's just look at the rules on where you have to go to in your circumstances of your particular case to get an injunction. And there are certain rules on this in the UPC agreement. The first, and perhaps most important of these, is that if you want a preliminary injunction, you have a choice of two places. You can go to where the defendant is domiciled, or, assuming they're domiciled in the EU, that is, or you go where the actual infringement has been threatened or has occurred. And as you'll see on this slide, those three boxes, the central division is the green one in the middle, and the blue boxes just represent the local and regional divisions. So on the left side, you've got the arrow going to the box where the actual or threatened infringement has occurred. On the right-hand side, you've got it going to the defendant's domicile. So the claimant has got a choice, and if, as some suppose, there are differences in approach between the local and regional divisions in the UPC as to the grounds on which they will grant a preliminary injunction, or to put it bluntly, it's supposed that some may grant them more readily than others. That choice you've got there, if you're a claimant, may be quite useful. There's another scenario where the claimant also has a choice. That's where the defendant's actually domiciled outside one of the contracting member states. So this time on the right-hand side, I've got the defendant outside the blue box. But still, if if the infringement has happened where there's a local or regional division, claimant can go there. But because the defendant is domiciled outside the EU, they've also got the choice of going this time to the central division, the green box in the middle. But the point is that the claimant still has something of a choice if its interest is in forum shopping. There is one third choice, which is going to be less likely in practice. That's if the defendant's domiciled outside the contracting states and there is no regional or local division of the UPC in the country where the infringement occurs. And that's because we expect most countries to be represented by a local division or participating in a regional division is going to be restricted to a handful of countries, possibly Malta, possibly Luxembourg. In those circumstances, there is no choice, and the action has to go into the central division. So with that, I'm going to hand over to Christoph in Düsseldorf.
Yes, thank you very much, Paul. So now we've looked at the background, and we really want to look at some details of preliminary injunctions. And the first question that arises is what kind of injunctions are available. So this is not a big surprise, as it is in most European countries. You can have ex parte preliminary injunctions where the other party, the defendant, is not formally heard, or inter partes preliminary injunctions with a hearing of the defendant. Of course, as a patentee, you want to go for an ex parte preliminary injunction and not hear the other side. However, you have to provide reasons for that. Specific reasons may be that there's a risk of irreparable harm that is suffered if the other side is heard, in particular if evidence would be destroyed, if the other party would find out about the PI request. Of course, ultimately, it's in the discretion of the court. It can decide if it is convinced by the arguments to issue a preliminary injunction on an ex parte basis, or if it feels that the defendant should be heard on an inter partes basis. What is interesting is if a party requests an ex parte preliminary injunction without the other party being heard, and the court does not agree with the reasoning of the patentee and says it will only grant a preliminary injunction or consider granting a preliminary injunction on an inter partes basis. In this regard, the PI request can be withdrawn by the patentee, the ex parte request, and if it is withdrawn, it will be kept confidential. This is in Rule 209, Paragraph 4. Of course, the patentee, if he says, okay, I went to one division and I'm not granted an ex parte preliminary injunction there, I may want to forum shop if that is available. Paul has just pointed out the options where one could go if there's actual or imminent infringement. So potentially there's another forum that can be used and a preliminary injunction requested. In this regard, however, it is stated in Rule 206, Paragraph 4, that the patentee or the plaintiff is under an obligation to state any unsuccessful attempts in the past to obtain provisional measures in respect of the patent. So it can't be kept secret that the patentee has already tried to obtain an ex parte preliminary injunction at another division and is now and has withdrawn its request and is now trying to do the same somewhere else. It has to point out that it already did this and was not successful. Okay, so now we will look at the details. Of course, how do we start preliminary injunction proceedings? First of all, formal side of things, you have to pay a fee. This is in Rule 206, Paragraph 5. As Paul already mentioned in the beginning, there's a provisional fee regime out there, and for preliminary injunctions, of course, this is only a provisional fee regime, it's not the final one. It has been determined that only a fixed fee should apply for preliminary injunctions in the amount of 11,000 euros. So it would not be value-based, but just based on this fixed fee. And considering the number of countries that this preliminary injunction may cover, this is certainly something that is very cost-effective. But again, it remains to be seen if 11,000 euros is the last word. The big question, of course, in preliminary injunction proceedings is demonstrating infringement. What has to be noticed is that there's a close connection of preliminary injunction proceedings and proceedings on the merits. We will touch on this point also at the end of the presentation. And so when you file a request for preliminary injunction, already you have to indicate the facts and evidence that will be relied upon in main proceedings on the merits of the case. Now, there are a lot of modes of evidence which are governed by Rule 170 following. So you have expert reports, you have an inspection of physical objects, you can have documents, witnesses, written witness statements, court experts. So a lot of different modes and kinds of evidence are available. And the question arises, which of these are applicable in preliminary injunction proceedings where the court may not have the full time to hear a court-appointed expert, for instance. So what has to be met as a threshold is a sufficient degree of certainty for the court that an infringement is present or at least imminent. And in this regard, the court will decide what evidence it will require to have the sufficient degree. Of course, if you're requesting an ex parte preliminary injunction, you don't want to wait until the court gets back to you and says, I want this and this and that evidence, and potentially also hear the defendant. So it could be worthwhile to, at least when requesting ex parte preliminary injunctions, put in as many facts and evidence that is already available and not rely on the fact that the court will ultimately decide what evidence is required in the preliminary injunction proceedings. So we've demonstrated infringement, and now we will look at some particulars of the preliminary injunction. A big question, of course, this is something that applies also in the national laws of the UK and in Germany. Is there a time-wise urgency? Justice Jacob once said at a conference, if somebody steps on your toe and you don't scream immediately, but weeks later, then it can't be a serious case for you. You don't need preliminary legal relief. And it's more or less the same in Germany. For instance, courts will generally look at how much time it took you to find out if there is infringement and what time it took you then to go to the court to file your request for preliminary injunction. As a rule of thumb, in Germany, you would usually have to file your request once finding out about infringement within 4 weeks. This is now, these national concepts of a time-wise urgency are now found in Rule 211.4, where it says the court shall have regard to any unreasonable delay in seeking provisional measures. Of course, at the present stage, it's not clear what unreasonable delay would be. It, of course, does depend on the circumstances of the individual case. But nevertheless, it has to be kept in mind, so you should act swiftly when finding out about potential infringement. Another big question is, does the court look at the validity of the patent? Now, this is a peculiarity, at least of the German system in the last couple of years, going back to some jurisprudence from the Düsseldorf Regional Court and the Zahnkatheter set decision, which basically adds the prerequisite. If you want to obtain a preliminary injunction, you have to show that the patent has a certificate of validity, as it's called, so something going just beyond the fact that the patent was granted. This could, for instance, be that the patent has already survived opposition or nullity proceedings, that there are noteworthy licensees who believe in the validity of the patent, or the court is familiar with the patent, has already decided on it, and perhaps proceedings on the merits. This is now also included in the rules, but it is not a shall provision, but a may provision. And Rule 211, Para 2 says the court may require the applicant to provide reasonable evidence that the patent in question is valid. So this is really up to the court, and it depends on the individual case. And then as a third criterion, this is now also in line, for instance, with the UK, there will be a balance of convenience, where, of course, the patentee will argue that he will suffer irreparable harm if the preliminary injunction is not granted right away. But the court will also weigh up the interests of the other party. Perhaps they're already contained in a protective letter. We'll touch on that also in a minute. So, we've demonstrated infringement. We've also satisfied all the other requirements. Now the question comes up, what happens then? The court may already render a decision at the end of the oral hearing if it's very urgent, the case. But the question then arises, can I immediately enforce such an oral pronounced decision, or do I have to wait for the written grounds? Of course, enforcement is something that the UPC does not deal with. This is something that is left to national laws. However, the UPC agreement or the rules do contain some provisions on enforcement measures. For preliminary injunctions, for instance, the court may order that a cost security in accordance with Rule 211.5 has to be provided. So in case the preliminary injunction is enforced and revoked subsequently on appeal, for instance, or if the patent is at a later stage nullified, there's a guarantee that will cover at least some of the costs of the defendant that he may have suffered from the enforcement. Rule 211.5 makes it clear that the order shall be effective only after the security has been given to the defendant in accordance with the court's decision. Besides this, and also another aspect that is noteworthy in this regard, if an ex parte preliminary injunction is requested and granted, a cost security will be the rule, whereas in inter partes proceedings can be ordered, but it is not a general rule. Apart from that, the question is there an enforcement deadline? As I already said, enforcement is something up to the national courts. For instance, in Germany, there's a 4-week, 1-month period within which a preliminary injunction has to be served upon the other party in order to enforce it. Of course, enforcement is not explicitly dealt with in the UPC agreement and does not set out any deadlines. So at the present stage, at least, we cannot guarantee that for instance, the German 4-week deadline does not apply. Rather, we would have to assume that it still applies if a preliminary injunction from the UPC court is granted. Okay, I think this covers this page. Another thing is for ex parte preliminary injunctions, it just says that the defendant shall be given notice of the provisional measures without delay, at the latest immediately at the time of execution of the measures. This is, of course, obvious. If the measure is executed, you will become automatically aware of it. Another thing I already mentioned in the beginning is that preliminary injunction proceedings are very closely connected to proceedings on the merits. So in the request for a preliminary injunction in accordance with Rule 206, you already have to point out what you will argue and what evidence you will rely on in proceedings on the merits. And this also ties in with Rule 213.1. So if you are enforcing a preliminary injunction and you do not want to have it revoked for formal reasons, you have to start proceedings on the merits within 31 calendar days or respectively 20 working days. If you do not do that, the defendant can request with the court that the preliminary injunction is revoked or ceases to have effect. Of course, if you enforce, you're liable for any damages that the defendant may suffer. This is governed by Rule 213.2 and then Rule 354, Paragraph 4. As a defendant, you may be expecting a preliminary injunction. For instance, if you're launching a new product on the market and you're fearing that somebody will attack it immediately when it comes on the market, so you can decide if you want to file a protective letter. I know that this is something that is, of course, a particularity of German law, but also in the Netherlands, whereas some countries like the UK may not be too familiar with these protective letters. So basically, a protective letter is a way that a defendant can already present his arguments to the court to mitigate the risk that the court will render an ex parte preliminary injunction. So it gives the defendant the right to be heard when a preliminary injunction request is being filed. A protective letter basically mirrors the injunction request, so you can provide arguments against infringement, you can provide arguments against the validity of the asserted patent. You can also include arguments why the case is not urgent, why the patentee has not acted in an urgent manner, so he's delayed his proceedings. And of course, you can put in some balance of convenience arguments that the harm that would be suffered if a preliminary injunction were granted and enforced would be tremendous on the defendant. As a rule of thumb, a protective letter should only be filed if good arguments are available. So, for instance, good, straightforward non-infringement or invalidity arguments. Otherwise, it could have a counterproductive effect and even trigger an ex parte preliminary injunction because the judge will of course look at the protective letter once a preliminary injunction request is filed. Before that, it remains secret. And if he's not convinced of the argument, he will say, oh, the other defendant does not have anything else to say. That's his formal position. I can now rest assured and grant a ex parte preliminary injunction. So the protective letter should only be filed if there are really good arguments available. From a formal side, these protective letters have to be filed at the registry in Luxembourg, and they must be filed in the language of the patent. They will be kept for 6 months, and this period can be prolonged, but then both for filing it and for the prolonging, a specific fee will apply. An interesting question is if a protective letter can already be filed during the provisional period. So Rule 5, Paragraph 13, relates to the so-called sunrise period, where opt-out declarations can already be filed with the EPO before the court registry is formally set up. So the question is, can this already, does this also apply to protective letters? It's not explicitly stated in the rules. It could be argued, at least it may be worth a try to file also a protective letter already during the sunrise period. Remains to be seen what the EPO would do with it. Sorry. And as I said, in Rule 202, Paragraph 7, the protective letter remains confidential and is not publicly available until an application for a preliminary injunction is actually lodged. Briefly then, to the appeal. The court does not grant the preliminary injunction. This decision can of course be appealed. The formal deadline for this is 15 calendar days of the notification of the order to the applicant. An interesting part of the appeal is, as there is a close connection to proceedings on the merits, which can be co-pending, what effect such an appeal of the preliminary injunction has on the proceedings on the merits. And Article 74, Paragraph 3 states that an appeal does not stop proceedings on the merits. However, the court of first instance shall not give a decision proceedings on the merits before the decision of the Court of Appeal concerning the appeal order has been given. So, and with this, I hand over back to Paul.
Christoph, thank you very much indeed. That concludes our webinar, but before I thank you and say goodbye, I do have two questions that are important and interesting that I'd like to answer that have come in. The first is that the question is the judge panel deciding on a PI the same as for the subsequent decision on the merits? Unfortunately, the answer isn't terribly simple. If the answer is basically if the PI is being asked for before a case on the merits has been filed, then there will be no panel to hear it. But the judge rapporteur, or if it's very urgent, a senior judge, such as the presiding judge, will hear it. Then when the case is eventually filed and heard on the merits, that presiding judge will be part of that panel, so there will be continuity there. Where it gets a little bit complicated is if there's later on a revocation counterclaim, which means that the whole question of where the decision is heard goes into the judges to decide whether it should be bifurcated or the whole infringement and counterclaim on revocation should be assigned to the central division. If it goes to the central division, then you get different judges. And I can see that one of the arguments that's going to come up when questions of whether a case should be bifurcated or transferred happen, the argument that there should be consistency of judges who understand the case and granted the PI in the first place would potentially be a reason for keeping it in the local or regional division. So I'm afraid it's not straightforward. Rule 208.2 is the one to look at in the rules of procedure. The second question, unfortunately, there is no straight answer to the second question, which is how long does it take to get a PI? All the rules say is, and I'll quote, the court on the application for provisional measures shall give an answer as soon as possible after the closure of the oral hearing. And if the court deems it appropriate, it will give an oral decision actually at the end of the hearing and follow up with a written answer, presumably in cases of emergency. But no, the rules are not currently tying the judges to any particular timeline. So it does remain to be seen how quickly those decisions will be handed down. So with that, thank you very much for joining us, and please do join us for our next webinar, which will be on jurisdictional issues. Thank you and goodbye.